In this tense court hearing, the state seeks restitution from the defendant for the victim's family following a fatal accident. The defense immediately objects, claiming they were blindsided with new evidence just hours before court and revealing a major twist: a $30,000 insurance settlement has already been paid to the victim's estate. The defense also fights to get their client's strict probation conditions reduced, arguing he's been compliant for years. The judge makes a crucial ruling on probation but delays the final decision on who must pay what, setting up a dramatic conclusion for a future date. Stick around to see the full legal showdown and find out what happens.
All right, so in this case, we're here for restitution. Are
Yes.
y'all prepared?
Well, we were just served with discovery, and so on that, no, because they're asking for restitution, which we had no notice of until today, about, I don't know, an hour ago.
All right, so State, do you have any witnesses for the restitution hearing?
And disregarding the document that she was served, I served them on her. I received it this morning and I served them on her as she appeared.
All right, so do you have any objection to their witnesses appearing by Zoom for the restitution hearing?
Yes, I do, because the lack of, so we filed a 3914 on February of 2024. And to our knowledge, there was no restitution at this point. We don't have the ability. We know that he was paid $30,000 in restitution from a insurance claim out of the insurance that covered the car that my client was driving. And so we don't have those documents. So at this point, we would let the court know that we can't proceed if they're claiming they're still entitled to restitution, even though they've been paid $30,000.
All right, so this is what are your witnesses going to be available at another date or no? All right, if you want to talk to them and see if they're available to testify at another date. If they're not available, I'll take their testimony, and then if they need to be recalled, they can be recalled. Okay. And I got your ex parte.
There's
So what I have to do is I send that it'll be sent under seal to the voucher committee. They'll look at it, and they're very quick about a quick turnaround, and then I can sign off on it.
okay.
All right.
But she's not available to testify.
All right, I'll take testimony today, and then if they need to be recalled, they can be recalled.
Great. And then, Your Honor, we do have two other issues that we'd like to address today too, just to put on your radar. And that is
Motion to reconsider.
motion to reconsider. And then the second one is that conditions of probation were amended yesterday without notice to the defendant. I think there was a report that was sent to the court that had to do, and it's not necessarily we're objecting to it, but we've not seen it. And he was ordered out, dual diagnosis, outpatient, AANA. We haven't seen any of that documentation. I talked to your court liaison, and she said that she can give us copies of it to review.
Okay.
But you'd have to authorize that.
All right, so I had ordered a TAP and MIC evaluation in custody. So are these the results of the TAP and MIC?
The TAP evaluation came back with dual diagnosis outpatient program. A supplemental report was submitted to the court yesterday or the day before yesterday, and it said for those conditions to be amended. Those conditions have not been amended just yet,
Okay.
But it is for dual diagnosis outpatient program, sober support meetings documented, and monthly UAs.
Okay. All right, and can you let her view the report, the recommendation, the TAP recommendation?
Judge, I need clear direction. Then you, are you saying give her a copy of it, or are you saying let her see it?
She can have a copy of it, but it's not to leave the courtroom.
I'll return it upon after review.
All right, court is calling 2023 CR 8868 State versus Samuel Allen Bach. Could I have parties announced for the record?
Megan Gallagher for the state.
Jody Sawyers for the defense, along with Samuel Bach.
And are you Mr. Bach? All right, so Mr. Bach, the deputy will tell you to stand there. We're here for a restitution hearing and also motion to reconsider conditions of probation. So we'll start with the restitution hearing first. State, do you have witnesses?
Yes, sir. State plus Carlos to make us June. Mr. Bach. Judge, I would just ask you to shoot us a notice of the evidence that was also dialogue.
All right. Did you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up so that the court reporter can hear.
All right.
All right, and excellent. If you'll state your name for the record.
Carlos Dominguez Jr.
All right, you may proceed.
Thank you, Your Honor. Mr. Dominguez, are you the same Mr. Dominguez that testified in the guilt and innocence portion of the trial against Samuel Block?
Yes, I am.
Okay. And in that testimony, you testified that Mr. Carlos Dominguez Sr. was your father. Is that correct?
Correct.
Now regarding the death of your father, did you make any arrangements for your father after he passed away?
Yes, I'm Trevino Funeral Home.
Okay. And did you have any pocket expenses associated with those funeral services?
Yes, we did.
Okay. And did you bring documentation of that to court today?
Yes, I did.
Okay. So I'm going to show you what has been marked as State's Exhibit number 1. Mr. Dominguez, I'm showing you what has been marked as State's Exhibit RP. Do you recognize this document?
Yes.
Okay. And is this a fair and accurate depiction of the documents that you provided this morning?
Correct.
I'm showing you what's been marked as State's Exhibit RP on there. Do you recognize that document?
Yes.
Okay. And is that a fair and accurate depiction of the document you provided with us?
Yes.
Okay. Now regarding the funeral services for your father, do you recall where they were made at?
At the Trevino Funeral Home.
Okay, and is that located on Couples Road here in San Antonio, Texas, Bear County?
Correct.
Okay, and regarding the out-of-pocket expenses that you had associated with that, can you tell the court what was a balance that came out of your bank account?
Objection, hearsay,
Overrule.
and also objection, no personal knowledge. If he's not the executor of the estate, a foundation has not been laid as to him having the authority to have it come out of his bank account.
Well, the question is, did it come out of his bank account?
That's what I was asking. So he would have personal knowledge if it came out of his specific bank account. The counsel's objection, if she doesn't know where it's coming from.
All right, so here's the court's question. Did it come out of your bank account?
My dad's account, which was the executive for the account.
All right, the objection is overruled.
Okay. Now, what was the total cost that was outstanding for the funeral service?
And Your Honor, I'm going to object that we have not been provided any documentation that this came out of a bank account. So any testimony in regards to what was distributed from the executor's account, we object under 3914 failure to disclose.
All right, objection will be overruled.
It was $4,545.51.
And is that the amount that you paid to the funeral home for the funeral service?
Correct.
Okay. Now regarding your father's home, was at the time of his death, were you living with him or was he living by himself?
He was living by himself.
Okay. And did you have any out-of-pocket expenses associated with his home after his death?
Yes.
And can you explain to the court what that was?
It was stuff that we were just getting rid of the excess stuff so we can get rid of the property and everything. Because none of the family wanted to keep the property. So it went through a junk lugger.
Okay.
And it took 3 trucks to get it done.
Okay. Now regarding that expense, I'm showing you what's been marked as State's Exhibit RPG. Do you recognize this document?
Yes.
And does that appear to be an accurate copy of what you provided me this morning?
Yes.
Okay, and can you tell the court what was the cost associated with that removal of the property from the home?
In Your Honor, again, I'm going to object. This was not provided to us until 9:30 this morning, and we still have not gotten a copy of this. We're just informed that it existed.
All right, objection will be overruled.
You can answer. So what was the total cost?
The first cost was $909.30, and the second cost was $1,204.77.
Thank you. You pass the witness, Your Honor.
All right, any questions?
Yes. First off, you would agree with me that the estate of Carlos Dominguez was paid $30,000 from a USAA settlement, correct?
Yeah, and I do not recall $30,000. And I don't agree with you on this.
Are you under oath right now?
Yes,
Okay. And you're the executor of that estate?
yes.
And what amount were you paid was the estate paid by USAA for this accident?
That amount I do not recall. The total amount I do not recall.
And was it over $20,000?
I don't recall.
Your Honor, this is why I'm objecting, is because
All right, so here's the thing. I've already made a ruling on the objections. I'm just having him testify now. He can always come back to be recalled to testify. This is what I'm going to tell both sides. With regards to these amounts, if there was an amount paid by USA settlement, then what the court needs to know is whether or not the settlement that was paid by USAA, if it was supposed to be for funeral expenses. It is not, if it's not for funeral expenses, then he is going to have to pay for funeral expenses. Now, with regards to the removal of property from home, everybody needs to bring me case law on that, on whether or not he is really entitled to restitution for that amount. Because what I can tell you, sir, is sometimes people will come to me and they want restitution for, I had to be out of work for a certain amount of days. And I'm not allowed to give, legally, I'm not allowed to give restitution for that. So both attorneys are going to have to bring me some sort of case law that will say that the removal from items from his home that you said went to, you titled it junk removal, and that's what I'll call it. The $909.30 and $1,204.77. So that was removal from items from his home. I'll need some case law on that. If somebody can bring the court case law that he is entitled to restitution based upon that. With regards to the funeral service amount, there's no question for the court that if that amount hasn't been paid by USAA, whatever the funeral expense amount is, that restitution should be paid by Mr. Bach. However, if documentation is brought to the court that in USAA, if that's the insurance company who covered expenses, if it's itemized in there, the funeral expenses, then if it's already been paid by USAA, you don't get to get it paid twice. You understand? So that's what the court needs. So we're going to recess the restitution hearing, and I'm going to give you all another date to come back, and you'll have a chance to look over whatever you need to look over. And then on that date, the court will make a ruling on the restitution. Okay? So do you understand, sir? All right. So Ms. Ferguson, with regards to the restitution hearing, give me a 30-day reset on that, please.
Yes, ma'am. October 16th.
All right. So we're going to continue with the restitution hearing on October 16th. All right, sir. Of him? Okay. She has some more questions for you.
So, do you have access to the bank account, for records for the executor? Like bank account?
That account has been closed. Yeah,
You were the executor, correct?
yes,
And you opened the account?
no,
Who opened the account?
my dad.
Okay, so it wasn't then, the executor's account.
I was on the account with him. When he deceased, well, on everything that was there, he had me down as the executor.
Okay, so the funds the account that you claim that you paid that, 4,000 and some change for the funeral expenses, are you on the account? Did you sign the check?
We used the credit card.
Okay, so it didn't come out of the executor's account?
Yes,
Okay, who owns the credit card?
I did.
Okay, so it's your personal credit card that
No.
paid?
That's the credit card that my dad and I were to go together, yes.
Okay,
We're together on it.
and so you have access to those statements, correct?
Not no more.
So you don't have access to the credit card statements?
I can ask the bank, see if we can go back and on the deal. I don't know if we can or not.
Now, also, who signed or accepted the payment from USAA? Was it you?
I did,
Okay, and are you the one that signed the settlement agreement?
yes.
Okay, and so you have a copy of that agreement as the executor?
Just like I said, I'm gonna look at my computer because I downloaded everything into my computer. And I still have it from again.
Okay, thank you, Your Honor.
All right. Any other questions?
No, not from us.
All right. Thank you, sir.
All right, and then,
All right. The next thing we're going to take up is you have a motion to, you can come back, Mr. Bach. You have a motion to consider, reconsider conditions of probation.
yes, Your Honor.
Yes.
At this time, at the time of the trial, you ordered 6 months of jail as a condition of probation. And at this time, he served over a month. We are asking for the court to reconsider. He had spent over 2 years on partial house arrest. We believe that he's a good candidate to hold that in abeyance. And, if there's ever any issues, you still have that at your disposal. This is not, a give me, it's more of an earned kind of thing. But he did, from the time of the incident, which has been over 3 years ago, he has not picked up any other driving violations. And at this time, we would ask the court to reconsider on that.
All right. Correct me. Wasn't the testimony that he doesn't drive?
No. It
I mean-
was initially that he didn't drive after the accident.
Mhm.
And then it took a long time for him to get back in the car. Once he got back in the car, he had been driving to work and back. That's it. To work and back. He lives in residential area rural area that doesn't have any public transportation. And the second thing to be considered would have been, if he is allowed out, and if that's held in abeyance, then we would ask that he have permission to drive for limited purposes of going to, work, his probation, his also, from what I'm seeing, they're recommending dual diagnosis, outpatient treatment, AA, NA, so he needs to be able to get access to those.
All right. So with regards to the AA and NA, is the court's understanding that those can be accomplished online?
Oh,
Is that correct? I believe it can be. AA or NA meetings that can be accomplished online?
Providers that have the online capability.
All right. State response.
We are asking that you denied our motion and leave the sentence as it was imposed by the honorable court on the date of sentencing. Regarding the 6 months, that is something that the state was seeking in punishment, as punishment, given the testimony and for the testimony of the defendant specifically as punishment. And then regarding his being able to drive, I just don't think that, given the facts of the case that were proven in the trial, that there are sufficient means to supervise him in a motor vehicle. And so we're asking that you leave the sentence as it was in the date of sentence.
All right. Then the next thing is with regards to the TAP evaluation.
yeah. And so, Your Honor, I have now had a chance to review it, and it looks like he has denied alcohol and marijuana use since January 22nd, 2022. And so at this time, I'm not quite sure that it's appropriate to order the dual diagnosis outpatient or the AANA, just because it doesn't look like there's a continued usage. It looks like he's gotten a hold of whatever was happening there. That doesn't mean that he doesn't need maybe mental health treatment, but as far as the alcohol and drug usage, that stopped over 3 years ago.
All right. So with regards to the TAP evaluation, they're experts. I'm going to follow the TAP recommendation. With regards to the motion to reconsider conditions of probation, the court is reconsidering those and the motion will be denied. So we will bring you back on October 16th, and at that time, we'll continue with the restitution hearing. All
Thank
right.
you.
And state if you will make sure that if there's any documentation from USAA, that the defense has access to that.
Yes, sir.
So with regard to the TAP evaluation, Ms. Abrams, the court is following that, but I'm not going to order that he be on sober support meetings for the duration of his probation. I'm going to ask for 60 sober meetings in 60 days. All right, thank you.